5, 4, 3, 2, 1. It took 4 years thereafter for the special judge to commence evidence taking for the prosecution. The said long interval perhaps helped the appellant, as is reflected from the fact that PW1 and PW2 made a volte-face in the trial court, and they denied having paid any bribery to the appellant, and also denied that appellant demanded the bribe amount. PW1 said for the first time that he acted at the behest of one Dr. K. Rao and went to the office of the appellant and did everything as directed by the said K. Rao. Both the witnesses were declared hostile by the public prosecutor and both were cross-examined in detail. After examining the remaining witnesses for prosecution, the appellant was called upon to answer questions put to him under Section 313 of the Code of Criminal Procedure, for short, the Code. He then submitted a written statement in which he said that Dr. K. Rao bore grudge against him and that person orchestrated this false trap against him by employing PW1 and PW2. According to the appellant, the tainted currency notes were forcibly stuffed into his pocket. He examined two witnesses on the defense side, and both of them said that on the dates when the alleged demand was made by the appellant, he was on tour at a different place. Both the trial court and the high court disbelieved the defense evidence in toto and found that PW1 and PW2 were won over by the appellant, and that is why they turned against their own version recorded by the investigating officer and subsequently by a magistrate under Section 164 of the Code. The special judge ordered those two witnesses to be prosecuted for perjury, and the said course suggested by the trial judge found approval from the High Court also. In the appeal, the High Court dealt with the contention that it is not possible to draw any presumption against the delinquent public servant in the absence of direct evidence to show that the public servant demanded bribery and that the same was paid to him. Learned single judge of the High Court observed thus on that aspect, it is true that there is no direct evidence in this case that the accused demanded and accepted the money, but the rest of the evidence and the circumstances are sufficient to establish that the accused had accepted the amount, and that gives rise to a presumption under Section 20 of the Prevention of Corruption Act that he accepted the same as illegal gratification, particularly so when the defense theory put forth is not accepted. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.